Good afternoon, everybody, and thank you very much for the opportunity to be here, and in particular to hear people and their responses, and even just the discussions between things at this particular conference. I think is really great, because I think we get a really good mix of people, which I think is a fundamental feature of this particular conference. So thank you for this opportunity to address what I call some salutary cases. And I suppose I talk about cases as being salutary in the same way that some people might say it's a brilliant case and some people say it's a terrible case. Either way, you're going to be picking messages and lessons out of cases as you go along as lawyers, and either trying to use it or hoping to God the other side doesn't use it against you when you move on to the next case. So I'm just going to mention three at the moment, and the first I'm going to mention is the Smith noise case, and I mention it because we were involved in it, so I should state an interest in that for a start on behalf of the RPA. And this relates to the Lewis line up in Dublin, the particular Lewis line, the one that goes, which I think is the green line, which makes its way from out in Loughlinstown all the way down through Ranelagh and into St. Stephen's Green. In this particular case, it looks like a very simple situation. I'm talking about how two particular individuals, a husband and wife, who lived in a house in Cambridge Terrace in Ranelagh, decided that the Lewis was just an insufferable nuisance in their life and had brought them to distraction by the amount of noise that it was making. And I think what you have to think about is this, not just in the context of the Lewis, of course, but in the context of any publicly created nuisance that anybody might be dealing with. All right, fine. Thank you. Okay, I'll move on from that one. Yes, okay. Thank you. So, in this case, it was before Miss Justice Lefroy on the 5th of March, and of 2010. So, I'm in the happy position that it hasn't actually been appealed, so we're okay on that. She determined that the Lewis line at that stage was being operated without infringing the comfortable and healthy enjoyment of a particular house in Cambridge Terrace in Ranelagh. Now, that sounds like a really small case. In fact, it was 16 days in the High Court, involving not only the RPA but also Ireland and the Attorney General, sort of somewhat similar to Alison's case that she mentioned, where the court said, listen, we have some fundamental discussions here, or fundamental questions which Ireland and the Attorney General need to stand up to and answer. We had a similar situation here where they were brought in, but from earlier on. And it all revolves around, I suppose, how public interests and private interests are balanced. So in this particular case, essentially, the Smiths were trying to bring an enforcement action against the RPA to stop them from proceeding in the way in which they were running it, and saying, you can't do that, it's too noisy, so you're going to have to bring in mitigation measures for us. That was what they were looking for by way of, if you like, a response, a remedy, was a compensatory measure to be put in place specifically for them. Now, obviously, there were a number of factors to this, and effectively what Judge Lefroy decided was that the RPA had the power to operate the Green Line in accordance with the light rail order. So as long as they operated the line in accordance with the light rail order, then they were operating in accordance with law, and it then followed, as a matter of statute law, that they could not be pursued for nuisance. It's important to put those steps together and realise that therefore there is a protection available, provided the operator operates in accordance with the order. In this particular case, the court actually determined that the RPA hadn't completely complied with all of the conditions of the order. They found that condition number 28 of the order had not actually been complied with fully. Condition 28 was a provision that required the operator to agree with the local authority on daytime and nighttime limits for noise levels. The reason that never actually got agreed was because informally the local authority was perfectly happy with the EIS, the limit set out within that. So in fact, they didn't look for, nor did the RPA pursue, separately complying with that condition. And the local authority was perfectly happy with that. But because there was a technical failure to comply with that, the court then said, right, now you're not fully in compliance with your order, so now I'm going to look and see, are you being a nuisance? Because if you were fully compliant with the order, you can't be a nuisance no matter what you're doing. But because you aren't, I have to now look at this point. So the court proceeded to consider whether there was in fact any nuisance, and what's important by way of a lesson to learn from this particular case was that, for instance, the standards that the court wanted to apply and was happy to find were the applicable standards were the NRA guidelines. And so those guidelines were considered best practice at the time, and they were decided to be definitively better than the World Health Organization guidelines or the British standards in this area. So we now have a definitive statement of law that stands up over those guidelines and says we prefer those to those other two. Those other two don't work in these circumstances. So that's something to learn. If somebody comes along and says, no, I have a problem and I have the WHO guidelines here and it says it breaches them, you'll know now that there's actually a statement of law in these circumstances that says that the NRA guidelines are in fact the appropriate ones to apply to a case such as this. In addition, at the oral hearing there were statements made and there were offers made, there were promises made by the developer, and that was considered and thrashed over by the parties as to what would they do for people who had problems. And she decided, the judge, that there was no binding representation to deliver screening during the light rail order process, so that there was no overall undertaking to do so. There were very weighty legal submissions lodged, and this all had to do with personal rights versus public rights. The constitutional issue really related to whether or not it was possible to say that we in Ireland allowed something to happen where your personal rights were infringed, but that was not on a compensatable ground, and whether that was allowed to continue to exist since we became a republic, because it is based in sovereign immunity, which obviously we had inherited from our British predecessors in terms of law. I'm going to quickly bring you through the submissions. The plaintiffs' submissions, which was the Smiths, was that they had suffered an invasion of their constitutional rights under Article 40.3 and 43, that the courts and the state had a primary obligation to prevent invasion of those rights, that the tort of nuisance existed to protect and vindicate those personal rights, that it wasn't possible to curtail those constitutional rights by implication in the interpretation of a statute or statutory instrument. In other words, it would have to be explicitly provided for in our written legislation that those constitutional rights could be infringed upon. And finally, that they were entitled to rely on the common law immunity in the present proceedings because no statutory provision for payment of compensation to them existed. And therefore, by implication, there was no way they could be compensated for those rights being breached, and therefore it was unlawful, and those particular protections should not stand in our law. The defendants, which would be not just the RPA, but in fact also Veolia Ireland Limited, which is the actual operator of the tram, they came along and said that there was no nuisance in fact or in law, that they had complied with all of their legal and statutory obligations. That was found to be not the case, as you now know. One of the conditions of the Light Rail Order number 28 wasn't complied with. That the proceedings weren't properly constituted because they said, listen here, we've been through an entire process. We've done an oral hearing, we've had days of argument. We are long past the judicial review period. We're years past the judicial review period. You can't possibly come along and start opening this up now. And they also said that the construction operation of the Luas, in compliance with the ministerial order, meant that you could not bring a complaint of nuisance. The AG said that, as far as the AG was concerned, there was no challenge to the constitutionality either of the Act or the order in the instant proceedings. They said that the courts have a primary duty to prevent invasion of constitutional rights, but the vindication of constitutional rights will frequently occur in the context of recognised torts. So they're saying the way you protect your individual constitutional rights is by pursuing a claim in negligence, in nuisance, in trespass, violence of Fletcher, whatever. They are all open to you to pursue, and that there doesn't therefore have to be an explicit provision that allows you to do that. They then quoted Article 15 and said that they felt that they were the Oireachtas was the sole and exclusive legislator. There had been no constitutional challenge either to the order or to the Act, and therefore they felt that it wasn't appropriate and it wasn't possible for the Smiths to bring that now. They said that the non-availability of compensation was a factor which could only go to the constitutionality of the statute or the statutory instrument, and since those haven't been challenged, you can't challenge them now. A number of principles were then considered over the course of that 16-day hearing by Justice Lafoy. They were, in short, and I'm very conscious of my reduced time, so the much larger arguments are in your paper, but the proportionality principle was brought to play, and you'll notice that that old favourite, Hanrahan and Merck-Sharp-Rondon, was recited with much approval. So the particular piece that was important was, I suppose, that what you were looking for was the comfortable and healthy enjoyment of your land to the degree that would be expected by an ordinary person whose requirements are objectively reasonable in all the particular circumstances. So it's a sort of a fusion of the man in the Clapham omnibus, but you're sitting in your house and there's noise going on. You're expected to be a reasonable sort of person. And you're expected to understand that when you're living in the modern world today, that there are certain things that you have to put up with, is the unwritten part of that finding. What's important, though, is to look at how it was then brought through. We saw Keaney in Ireland being mentioned. We saw Times newspapers in the United Kingdom. And eventually, when they look at what is proportional, how do you decide what is a proportionate response to something? You have to say that, firstly, it must be rationally connected to the objective. It mustn't be arbitrary, unfair, or based on irrational considerations. It must impair the right as little as possible. So there's an understanding that there's an impairment. It's a question of degree, as little as possible. And finally, that be such that their effects on rights are proportional to the objective. And if all of those are taking place, then that's actually proportionate and should be allowed. The defence of statutory authority, or legislative authority as it's known, was then raised again. This had to do with whether or not legislation specifically provides that there's a preservation of rights in actions for nuisance, despite legislative authority for the commission of certain undertakings. And this is the balancing that went on. Ultimately, the finding there was that, well, the Attorney General submitted that it followed that legislation could curtail your right of action, not necessarily even by necessary implication, but by its very existence and requirements. In other words, just because there's an act, and in this case, obviously, you're looking at light rail order and the light railway system, if the act doesn't specifically say, by the way, when we implement this scheme, it means that certain of your private rights are going to be curtailed, it doesn't need to say that to be able to still afford you the protection of compliance with that act. And the constitutionality of statutory immunity was raised. In other words, we can't possibly allow statutory immunity. It's an old hangover from the British regime, and we shouldn't be still having it. Now, in fact, it didn't have to be gone through in that much detail because of the way in which Ms. Lafoy eventually formed a view of how it worked. The role of the EIA and the EIS was extremely important in this case. The EIS, if you want to see what does an EIS do for you, what the EIS does for you in this case is it sets out in great detail the thresholds which you expect to abide by. It actually limits you and curtails you insofar as there are specific thresholds set out. So it's not just a general oblique description. It is a very specific limitation on you. And in this case, it was decided that what was provided in there would be made, be stuck to the RPA one way or the other, whether they liked it or not. As it happens, they liked it because they found that they were working within it. They found that, but actually not as much perhaps earlier on as later on. So they were able to show that they were working to the upper limits originally, but by dint of doing works on the tracks, they actually reduced it, and they had objective data that proved that. Now, all of that was important because you brought the personal factors in then, because of course this is legislation with two individuals against a very large series of companies and Ireland and the Attorney General. The personal factors were brought into play without any doubt. And in this case, there were, if you look at this claim of noise and nuisance, it was pursued on three separate grounds. First was that the Luas generated a level of noise which, without the Luas, wouldn't exist. I think that's a fact. Nobody had an issue with that. Secondly, that their evidence from the plaintiffs was, as a matter of fact, the noise levels caused distress, and there's no doubt about this. It caused them great distress and inconvenience. There's no doubt about that as well. And thirdly, that their own experts, the plaintiffs' experts, gave evidence that the nighttime noise levels exceeded the World Health Organization guidelines, and that's what they were hanging their hat on. They didn't. What you're looking at as well is the fact that their house was described as being located about 1 mile from the city centre of a city with over 1 million inhabitants. The issue about background noise levels was gone into great detail. What noises do you actually hear when you're located in Cambridge Terrace? And what are you expected to put up with? And so ultimately it appeared, because neighbours came in who in fact were nearer than they were, who said they had no difficulty. And also they did not take part in the oral hearing. They did not engage in the process. And that was a very bad move. It turned to be, it's not something they actually said, we read the non-technical summary of the EIS. We did see that. We knew it was coming. Everybody knew it was coming. We read the NTS. Nothing struck us as being problematic. But the point is, it was looked at very, very carefully. Most of that oral hearing was about the noise. And particularly for their section, it was all about the noise. They did not engage. So if you ever want to know, why should I be bothered going to that oral hearing? Here is a very good example of why you should be bothered. Even if you don't get what you're looking for in it, engaging in the process is important. The second case I want to mention is 5009, which is just issued the 3rd of March 2011 from the ECJEU, and that is 3 complaints against Ireland on the failure by Ireland to fully implement the EIA directive. Another EIA complaint for failure to fully or wholly or properly transpose the EIA directive, and another finding that yes, we haven't. And all 3 findings were against us. I'm not going to go into the third of the 3 because we've actually already ameliorated that. That has to do with the situation where there was an Irish National Monuments issue in relation to demolition, and how demolition works weren't in fact included automatically in EIA or EIS-able projects. Now it's considered a project. You will have to get environmental impact assessment done in certain demolitions, and so that's all right now. We've amended our hand, so I'm not going to talk about that anymore. The other 2 remaining complaints are very interesting because they have to do with an area that I know is very dear to the heart of many people here in the audience, which is, if you like, the dual consent or split consent, however you want to look on that process between the EPA and on board Planola when you're looking at major development, and where you're looking at a situation where how that is carried out in the context of complying with the obligations under the EIA directive. Ireland's difficulty arose out of the manner in which the EIA had been incorporated into the planning processes. As you know, we have firmly locked it into the planning process. That's how we've implemented it. And so, as a result, you have a situation where it was found that when you had a project that required both a permit from the local authority or from the onboard Planola and an operational licence, be it a waste licence or an advocate licence from the EPA, that when both parties were involved in the decision-making process, that there was a potential gap in the middle. Now, the gap is not, and it's important to note this, the gap is not that we are actually bringing 2 separate entities together to make the decision. That's fine. As a matter of principle, there's no issue with that at the European level. The problem is they looked at it and they said, there's a possibility here that when you apply, say you apply to the EPA first for your IPC licence or your waste licence, say you do that. If you do that, the EPA is not entitled to oblige you to carry out EIA and to lodge an EIS. That's a problem. Even if, when you do an EIS on the planning side, the EPA says, show us the EIS, we'd like to go through it and with a fine-tooth comb, please, that isn't sufficient. And no matter how much we try to explain it, actually we cover it over in this way and that way, and that's how it works. And don't worry, Europe, we actually do sort it out on the ground. Europe said, no. Even if you do, the problem is your legislation does not allow the EPA to require an EIS to be submitted in solely its process. And that's where you have fallen down. Now, I imagine that's quite easily amendable, frankly, in our legislation. It's a very neat point. And the second part was that there was also a lack of obligatory consultation between the 2 parties. So when you have 2 decision makers working at the same time, there is no obligation on them to, I suppose, coordinate their review to work on the consent process and require that there is an obligation of backwards and forwardsing. So that's why I have to say oftentimes you would say, well, you just have to go out and ask them. They don't actually have to come back and say anything to you. As long as you've done that, you've ticked the box. Ticking the box is no longer good enough. We will have to go much further than that. So all of those three are against us, and we are in a state of trying to decide what to do next to deal with that. And I imagine that there's a few people who are working on how we address those issues that we've already addressed the first point about demolition. And of course, costs were awarded against Ireland. I'm always very keen as a practitioner to ask about the costs aspect of things. And in fact, I know I was very interested to hear that question this morning, I think from Peter, speaking about how do that costs go for that lady in relation to the bats. National legislation. If I move on to my final case, because I'm totally caught out on time here because of the way the day has run, and I'm not going to spend too much time on it because already Alison has already covered it in much greater detail. I just wanted to mention a couple of points on it, and this is the most recent Nephin waste case. And I think I'm conscious of it for a couple of reasons, because it's very interesting to see how it panned out. Firstly, I suppose it's because you were looking at a situation where there was the EPA felt on safe ground. They clearly felt very comfortable in relying on the Fenton No. 2 case. Which is relatively understandable given that it was officially case law. And I have to say that case is close to my heart because I was involved in the Fenton No. 1 case. So insofar as the Fenton No. 1 case managed to reduce the people involved in the Fenton No. 2 case, I'm very pleased to see that, and I watch it carefully to see how it went after that. So in this case, there's a small part of there, but for the grace of God. Looking at it, you see how did that work, and I'm very conscious that you had a situation where they clearly felt they could rely on it for their fallback order. But what's important to look at really was that we all understood that that case was about the polluter pays principle. We have all known since that case was decided that there was a question mark over it, and everybody also noted that no appeal was brought for all sorts of different reasons, which I'm not able to divulge, and I actually don't know all of them. So you knew you were left with a case that, as far as most lawyers were concerned, had a question mark over it. It was still just case law there, pure and simple, but it was in a very wide picture. And I think that the clever thing to have been done in this case was to have reduced something down into a very neat question about the law that applied and how it should be working here in Ireland. And I think you have to bear that in mind, because if you look at Fenton No. 2 case, it was also argued at the time that really it shouldn't apply anymore anyway, because the law had changed fundamentally since that case had been decided. But Mr. Justice Edward decided that he couldn't wholly ignore the reasoning, and he felt that he really had to look at it from the perspective of the polluter pays principle. I think it's what's important to note is that also the court formed the view that if it was the intention of the Oireachtas to apply that principle, you might have expected to have seen it in specific wording. And it's not there. It's a question of statutory construction. And if it's not specifically there, there are only limited circumstances in which you can imply something in. And then you look at the principle of separate corporate personality. And it was accepted, and I think it's a bit back to a question that was asked earlier, what happens when a company goes wallop? It was accepted that this concept of separate corporate personality, it wasn't the be-all and end-all. But as far as the directors were concerned, they put it to the judge that really it's not something, although not set in stone, has to have had regard to. You mustn't disregard it. It's there for a purpose. And the fundamental nature of the separate legal personality principle meant that if it was to be removed, then there should be an express statutory provision under whatever section was being pursued at the time. That was not there. And it was plain to see that that was a very, very good position. And it was a very good thing to be able to say, and it is in the same act in other parts of this act specifically, but it's not in this one, not on the civil side. So I think that's important. And if you look at that, you'll see that we're looking at a position where the judge himself said that he actually, when he read it, he said, the problem is that as far as the EPA has gone in looking at it, they have simply, he said, you are missing the point. You are missing the point. He says the preliminary questions formulated asked whether on a true construction of the law, a fallback order may be made, and he highlights this in his judgment, whether a fallback order may be made against individual directors and or shareholders of a corporate entity under the provisions of the Waste Management Act 1996. And the judge personally emphasised those things. He just said, actually, you've got it wrong. You have spent too much time focusing on the European side of things, and you have not looked at how we deal with things here in Ireland. So finding that there was no such entitlement to make such orders against the particular individual directors was a very important point, I think, in that case. I think that's all I'm going to say, because I know I'm tight to time. So thank you very much for your attention.